Good afternoon, everybody. I hope everybody's having a great Thursday, getting ready for Thanksgiving next week. Today is going to be more of a personal angle for my estate planning talk, but it's really something that can apply to everybody. So again, hi, my name's Heather. I'm our estate planning attorney here at the Legacy Legal Team. And like I was just saying, I have been engaged for about a year, so estate planning with my fiance is something that we've really been talking about and trying to figure out what we are wanting to do. I do this for a living, so it's something that's easy for me to talk about, but it's not necessarily something that a lot of people think about, especially in that weird in-between of being engaged. What I'm going to talk about today is still going to apply to everybody, whether you're single, whether you're in a long-term relationship but not engaged, whether you're engaged, have a life partner, married, whatever. You can learn something from today. But it's especially important, I feel, for those that decide that they want to be in a long-term relationship or engagement where you really do trust this person and you want them to have some say in things, but you're not legally married, so they don't legally have a right to have a say in some things, especially like healthcare and those types of decisions. Again, I'm framing it as from that point of view with an engagement, but it really does apply to everybody. And so the big crux of the discussion is going to be what documents are available to somebody that they don't want the normal thing to happen. So the normal thing, if we're listening to what the law says with no input whatsoever, you've done no sort of planning, generally your parents are the ones that are going to make decisions if something happens to you. For medical decisions, if your parents aren't around, it'll be siblings and so on and so forth. Same thing with who's going to get your things if something happens to you. If you don't have children, it's going to be your parents. For a lot of people, myself included, that may not be what I want to happen. So we've come up with the need for some basic documents. So if you're in that interim, you're thinking, okay, we're going to get married, let's hold off on the big decisions like maybe a trust. It doesn't hurt to have some things in place now, especially some things that don't necessarily have to be changed, or it can be drafted in such a way where it can still have the same effect once you get married. So one of those things obviously is a will. Everybody that comes to me, I shouldn't say everybody, most people that come to me say, Heather, I want you to do a will for me. It's the one thing that everybody knows about as far as estate planning. And wills are great, especially if you don't want the normal thing to happen, which is, again, it's going to go to whoever the law says if you die, and who's going to be in charge of those things. A will, you can say, okay, when I pass away, I want this person to be in charge of getting it all sorted, and I want my things to go to this person or people. Cool, great, wills are fantastic. The only bad thing about them, we still have to go to probate. That's one really big misunderstanding that a lot of people have. We still have to go to probate, generally, if we're only relying on a will. And there's other things that we can do besides a trust, and I'll briefly mention some of that, but that's like on a case-by-case discussion and talking about what you have and what your goals are. But probably two of the biggest documents that are important for the situation are your designation of healthcare surrogate and your durable power of attorney. Healthcare surrogate is exactly what it sounds like. So this is the person that is going to be able to make your medical decisions for you if you're not able to. Again, right now, if something happened to me and I went into the hospital, my mom and my dad would have equal authority to make that decision. My parents are divorced. I don't know how that would go. But I also have been with my fiance for almost 9 years, so he knows what I want to happen. He knows my wishes as far as life support and those types of things. So do my parents, but it's maybe at that point where I consider naming him there instead of just waiting until we get married and then him legally having the right to make a decision for me. This is especially important if you are with somebody who you're not married to, but you have children with, or you are having a child together if you're pregnant. I have a friend who had some complications from a birth, and the father of the child could not make the decisions for her. It went to her parents. There's a lot of times where this is really important. People just don't think about it because most of us were young. We're not thinking about anything happening to us, but my job's to worry about that for you. So yeah, like I said, with a healthcare surrogate, you can name as many people as you want. So you can name your significant other first, and then your parents or your sister or your brother or best friend. But that way you have the person making medical decisions for you that you trust and who knows what you're going to want. Especially if it's somebody that's more local, sometimes they're more easy to get a hold of. Or will be the one that takes you to the hospital if something's going on and they don't have to worry about reaching your other family members. The other side of that coin is the durable power of attorney, which is a little bit more of a scary document, and that's something that I spend a lot of time talking to my clients about, because while I think if somebody's going to have one document, I think everybody should have a durable power of attorney. It's that important. It is a scary document, especially the version that we draft. Essentially, the power of attorney gives somebody the ability to make decisions for you. It's usually only used if you can't make that decision yourself, so you're unconscious, you have some sort of incapacity, but somebody needs to be able to talk to your landlord, somebody needs to talk to the IRS, somebody needs to talk about your car lease. Like, any of these things need to access your bank accounts. Your power of attorney gives them the power to do that. The bad thing about it is it gives somebody the power to do that. So in Florida, we don't have the type of power of attorney where it waits until something happens to you. It's valid as soon as it's signed. So somebody has immediate access to your accounts if they have this document. So again, important to trust the person you're naming, but I think it's a really important document because, again, you never know what's going to happen. Let's have something in place. Even your parents won't have access. The normal person under the law, they don't have access to be able to do these things for you. So if something happens and somebody needs access to these things, we actually have to go to the court and try to get access. Of course, this is assuming that there's no joint ownership or things like that. But to me, like I said, power of attorney is probably the most important document that I think anybody across the board can have, doesn't matter what your age is, what point in life you are, if you have kids, if you're married, whatever. Everybody can benefit from a power of attorney because you never know what's going to happen. I mentioned earlier with a will, we're generally going to have to go through probate. There are ways to avoid it. Like I said, trust is really beyond the scope of what I want to talk about today, but that generally can avoid probate. Another way that we can avoid probate in a lot of situations, especially for people who have less assets and have less people that they want to get things to where there's not a lot of room for disagreement, is by doing beneficiary designations. So a lot of people know this in the context of retirement accounts or life insurance, because when you set up those accounts, you're prompted to name a beneficiary for if you pass. For example, I know my fiance, when he created it, he added his brother as his death beneficiary. We had a discussion recently. Hey, we've been together for a long time, we're living together, we have joint responsibilities as far as finances. Maybe this is a time where we start thinking about naming each other. We're not married yet, but maybe start thinking about it because we've been together for so long. Of course, this is a personal discussion that you have with somebody. And again, it applies to anybody. It doesn't matter if you're engaged, but you might have somebody that you want to make sure that you're named on beneficiary designations. And like I said, those are usually prompted for certain types of accounts, but you can do it on any type of account. So your checking, savings, brokerage, money market accounts, anything you have, you can name the payable on death beneficiary. And that actually keeps those accounts or those specific assets out of probate. In Florida, we can actually do something similar for real estate too. Generally, I think it's a great option. It's called an enhanced life estate deed or a ladybird deed. But again, for some people, that's not the best option, but it is an option and it does keep the property out of probate. I'll circle back to this in a little bit because a lot of people have come to me recently and say, okay, I have my own separate assets. I bought a house before we got together, whatever the situation may be, and they don't think about a lot of things. So I'm going to talk about that at the end of this. But that's the world of what estate planning attorneys can do as far as the basic documents. We can do a will, healthcare, power of attorney, beneficiary designations, and then like I said, depending on what you've got and what your goals are, we can do a trust. But there's a lot of things that need to be thought about when you're considering marriage specifically. The number one thing that everybody's going to think of when I say that is, let's get a prenup. Prenups have their place. They're not right for everybody. They're not right for every couple. I have some families that require and refer to their kids to get anything from an inheritance that they have to sign a prenup. I have others that say, you know what, let's leave it up to them. I have some clients that definitely want a prenup. I have others that say, I don't care. We don't really have a whole lot that we're bringing into it. So anything that we make together, and if something happens, then we share it. But that's definitely something that is becoming more and more important and more easily discussed, I feel like, than it used to be. And I think it's because a lot of people, as they're getting into this stage of life, they are keeping their separate assets. I'm seeing a lot of yours, mine, and ours. So we have a joint account where all of our bills come out, but then we each have our fund money to do what we want with it. And we have some older couples that are that way, but I see it a lot with the younger groups. Nothing wrong with it either way. But there are different types of planning and different things to consider when you're holding your assets that way. So that's one discussion that you really want to have with people before you decide that next step of marriage. If you're keeping things separate, maybe a prenup is the best option. So something that, like I said earlier, people don't really think about is just because you brought it into the relationship as a separate asset doesn't mean it's going to remain a separate asset. And that is mind-blowing to people. Okay, it was my asset when I came into this. Why don't I get to automatically decide who it goes to? And with a lot of things, that's still true. In Florida, it is somewhat easy to commingle property, but it's usually just on the increase in value or things like that. So there's ways to limit it in the context of divorce. The scary thing is there's very few people that think about what happens if I'm married and I die. I have had several people this year that come to me and say, Heather, I came into this marriage, I have this house that I inherited from my grandmother, for example. That's all well and good if you get a divorce and it stayed in just your name and you didn't put there's not like a big increase in value that was based on time or money spent from the marriage. Cool, that stays your separate property. But if you die, that's not always the case, especially if it's a house that you were living in together as your primary residence. Under Florida law, that's considered your homestead. And there's all these extra constitutional protections that are built into the homestead. When you hear homestead, you automatically think taxes, but that's not the only thing. There's this constitutional part of it as well. If there wasn't a prenup or postnuptial agreement or another spousal waiver of rights, if you die, your spouse is automatically entitled to a certain amount of your assets, which is scary to a lot of people because they don't realize this. Generally, they're able to remain in the homestead if it was their primary residence, at least for their lifetime. So they get a life estate in the property, or they get a half interest to share with other beneficiaries. They're also entitled to a certain amount of money from you. So there's this thing called like the spousal or family allowance where they get to keep some money, and this includes things that have those payable on death beneficiary designations. I could say my account is POD to my best friend Kaylee, but if I'm married when I die, that's actually considered part of the amount that my husband might be able to access. A lot of people don't realize this, and it's scary. So this is really where I think it's important to always consult an attorney if you're considering a big life change. Whether you're having a kid, whether you're getting married, whether you're getting a divorce, whether somebody in your family's passed, go see an attorney. A lot of us do free consultations for this type of discussion just to get a bearing on what is actually truth, because we all know Google lies. But a big part of what I do is I consult you about what documents I can prepare, but I also consult you about these are the things you need to be thinking about while we're doing this process. Again, I'm going to use me as an example. I'm getting married. We need to talk about whether we're going to get a prenup. We need to talk about whether we're going to have a spousal waiver for our cash accounts or real estate. So yeah, that's, like I said, it applies to everybody, but I coined it in the situation of getting married. But this is stuff that even if you have been married for a little bit and you realize, oh goodness, okay, I thought this was my property, it's something that can still be taken care of. It's not set in stone so long as your spouse is agreeable to sign the documents. And most of the time, I find that the discussion was had before the marriage and everybody was on the same page, but the law is not on the same page. So we can do things like a spousal waiver or a postnuptial agreement. And that's all stuff that you definitely want to go to an attorney for to make sure that everything that needs to be waived is being waived. So yeah, that's it for today. I wanted to keep it short, sweet. I know a lot of people are focused on the festivities of next week already, myself included. So I will stay on for a few minutes to see if there's any additional questions, whether it's about what I've talked about, estate planning in general. But yeah, I'm glad if anybody joined me today live, and if not, you can always catch us on YouTube or on the recordings on Facebook afterwards. Alright, well, I am not seeing any comments come through yet. Thank you again for anybody that joined live or is watching it after the fact. Feel free to drop a comment and somebody will get back to you. I hope everybody, we just got a message. Somebody said that when's a good time to consider estate planning? All the time. There's not really a specific time. It's just when you feel like you are ready to discuss this. It's a hard topic. you're thinking about dying. It's not something anybody really wants to talk about, or you're thinking of something catastrophic happening to you. Nobody wants to talk about it. But what I always say is come back and talk to your attorney. Even if you have an estate plan, come whenever there's a big life change that just happened or is about to happen. So again, like I said, marriage, divorce, death, new child, moving, anything like that, always a good time to start thinking about estate planning. I have college kids that basically have no assets that still come to me and get an estate plan done. I have 100-year-olds that come to me to get an estate plan done and everything in between. Just because you don't have a ton of assets or just because you think that things are going to be simple doesn't mean that's necessarily the case. Doesn't hurt to go talk to an attorney. Alright, I hope everybody has a good rest of their day, enjoys their Thanksgiving next week, and we will chat soon. Have a good rest of your day.